Nkuntima and Company Advocates, translating visions into reality.
Intellectual property, it could be the gap between passion and a job. If musicians, artists, content creators could embrace copyright registration, they could have ownership to whatever products that they're having, which could lead them to license. That could be a way of them generating revenue.
All right, ladies and gentlemen, you are most welcome to our discussion this week on World Intellectual Property Day 2025. And we are having this discussion under the theme World Intellectual Property Day 2025, IP and Music. And so this time round, we have our team leader, Intellectual Property, who will get to introduce himself soon and in more details. But my name is Howard Mwesigwa, and I'm your host today. And well, let's get into it. De Klerk, you're most welcome. Please do introduce yourself to our audience, and then we'll delve deep into our discussion today.
Thank you, Howard. I'm Louis De Klerk, team leader, intellectual property. And I lead the team and foresee that we help our clients towards achieving ownership of their poetry rights. Yes.
Okay, great. So without any much ado, De Klerk, let's get into the discussion. I mean, we have seen the global traction on intellectual property, but we also know that in Uganda this is something relatively new. We have the law, and we will get into that, but we still see that there's some gaps, especially with the creatives that do not know some of the safety valves that this law provides to them. And on our end, of course, trying to bridge the knowledge gap to get them to know some of the rights that they have, but also how they can take advantage of the laws. So in the first place, from your experience and the work that you've been championing here on intellectual property, how, in your opinion, how does Uganda's current IP framework support or hinder the protection of innovation and creative works, especially when it comes to music and the creative industry?
Thank you, Howard, for the question. When it comes to the realm of music and creative works, we have the Copyright and Neighboring Act. It says that protected work is not infringed. It also says that related rights go unnoticed, and it emphasizes that work is original if it hasn't fallen in the public domain, and it appreciates the works of the authors. However, what distinguishes work that somebody has done and work that is capable to be protected is that work that is capable to be protected, it should be work that has been reduced in material form. Now, material form, we're looking at work that is, for example, recorded and it's on the CD, particularly. It's in the CD, work that is written on paper. Now, that is work that is capable of protection, not ideas. Of course, I could have a very good idea, talk about it with a friend, but if my friend puts the idea in material form, now that is work that is capable of protection. And the law streamlines how the process is for registration of copyright. Work should be put on a CD, submitted for registration, and it's examined. If it passes the test, you are issued with a notice to Gazette to inform the general public that so and so intends to protect this piece of work. If anyone has an objection, it should come up. Short of that, the directorate will proceed to issue with the certificate of ownership. Of course, as we celebrate the World Intellectual Property Day, a lot has been put in place, especially by the Directorate of Intellectual Property. That is one of the functions of URSP. A lot of sensitization has been made, and they've been on all their handles. They've been encouraging artists to register their works. But the only loophole we face in the field of entertainment world, and in particular in Uganda, people seek protection after their work has been infringed, or when they feel that their work has been infringed on.
Right.
And when you are to check on whether any process had been undertaken to see how far were these individuals, how far were the artists towards formalization of ownership. And you see, it's something that they hadn't started on. Yet, how our law is framed is that ownership is by issuance of a certificate. So it puts both the Office of Copyright Registration and the intellectual property practitioners at a state of confusion, because we are looking at you're trying to represent somebody who claims work has been infringed on, but there's no way how the law is going to come up and say, okay, this is actually your work. And at the same time, you're facing a scenario of the other party is presenting to the officers that actually this is my work, this is the certificate. So that is the scenario we find ourselves in.
Wow, that's interesting. You know, when you mentioned that here in Uganda, and I think mostly in the global south, many people wait for the infringement to happen, for them to seek legal redress, but also many people wait after a while to sort of register, the intellectual property. They first go on, with the work they're doing, and then eventually register. And we've seen that in many scenarios, someone can, steal the idea, quote in quote, and yet in intellectual property law, you cannot steal an idea per se. Yeah, so it's been a major challenge. But in your opinion, then, what role do you think intellectual property plays in empowering young innovators and artists to turn those ideas into sustainable livelihoods, and what gaps do you see that still need to be addressed?
First, intellectual property. It could be the gap between passion and a job. If musicians, artists, content creators could embrace copyright registration, trademark registration, and the design, they could have ownership to whatever products that they're having, which could lead them to license. That could be a way of them generating revenue. But we face a scenario where individuals rush to let their works to the public domain before the formalization process is done. So once work is already in the public domain, you find yourself that you have no remedy at law. And you find yourself, you've exalted the means through which you ought to have benefited from these works. Now, I'll give a scenario. Let's say somebody makes very interesting work. Let's say somebody makes a very interesting, it could be an ad, but he rushes to post it on various social media handles. I mean, the circulation and use of the work, it already reduces how much this person could have achieved from this work. And let's say we have now in the realm we are living in of technology, corporations these days prefer marketing their services online. So if a company reached out to this individual that they would want to use their work, one of the things they would inquire is that proof of registration or proof that this is your work. So failure to prove that this work is actually yours, the company will believe you also copied the work from somewhere else, so you don't have the moral rights in the work. And failure to establish you have the moral rights in the work, it affects an individual to be able to derive economic rights from that particular work.
Well, amazing. Speaking of the digital age, from your experience, De Klerk, how do you think the rise of digital platforms and artificial intelligence, how do you think these notions have influenced the enforcement and commercialization of IP rights, especially in terms of music and the creative arts?
We are living in a world of a digital age where everything can be obtained by a click of a button. How this has aided or how this has facilitated the growth of intellectual property. It has done this in very many modes. For instance, it has enabled artists to become more creative because of very many things that are shared online and very many things that can be accessed. Artists are able to think outside the box, to come up with new ideas, to be able to do the same thing that is already out there in a different mode, which I would say has given them a platform, if I may say, for their works. Yes. Then how this has also helped for those that have already gained recognition, how it has been able to influence or aid enforcement is that they're able to monitor the usage of their works. In that somebody who uses their works without authorization, somebody who uses their works without acknowledging who the authors are or who the content owners are, they're able to follow up with those particular individuals. Yes.
Well, don't you think though, De Klerk, that because of the rise, the usage of digital platforms, that has been a source of infringement, instead where people are freely sharing, these pieces of work without even alluding in the slightest way to the authors or the owners of the intellectual property in these works?
Like I said earlier, that for copyright, it protects work that has not yet fallen in the public domain. But we see that there are very many social media handles. We are seeing there are very many digital platforms.
Yeah.
So as an artist or as a musician or as content creators, you should be able to disseminate that my work best performs with this particular platform because it has controls that my work will not be duplicated. For example, how some of the artists are able to generate incomes from these particular platforms. For instance, they enter into agreements with these particular platforms. They aid uploading their works, but they make it hard to download unless a particular fee is paid. So within that, you're able to tell that my song has been viewed this number of times, my song has been downloaded this number of times, which aids to compute how much you would earn from these particular platforms.
Okay, great. How about the question of artificial intelligence? How has that shaped the intellectual property landscape, in your opinion?
So with artificial intelligence, intelligence. It has aided artists to be able to compare their works and also add something that may be missing. Then when it comes to the part of the practitioners, with artificial intelligence, we are able to determine whether this work is original, whether this work is duplicated, or whether this work is completely AI generated. Yes.
Wow, that's interesting. One would be wondering, we might be talking about all these different things related to intellectual property, but what exactly is intellectual property, anyways? Probably we should have begun with there, in the very beginning. But what exactly is intellectual property, De Klerk?
Intellectual property, these are intangible assets of creative works. I would say, for instance, what would be intellectual property? It would be if I register my music and I get a copyright registration certificate. So I own copyright. I own the intellectual property, which is copyright in that particular album or these particular songs. If I register a trademark, so I hold proprietary intellectual property in that particular trademark. If I register a design, I own the intellectual property in that design. So owning intellectual property in copyright, trademarks, design, it's a property that is intangible, but it enables me to brand myself, it enables me to identify myself, and it will enable me to get financial value from that particular product. Yes.
Thank you, De Klerk. So, to sort of move away from that, just want to find out from you whether you have, say, a landmark case or an example where strategic IP protection has significantly elevated a Ugandan creative or innovator's career, and what lessons can we draw from it?
Okay.
Yeah.
That's a good one. And we have a recent judgment from a commercial court by Honorable Justice Patricia Mutesi. That is in light of the matter of Bruno K versus Black Market Records and others. And in this case, we saw briefly the facts were that Bruno K had entered into an agreement with the record label, and the major issue was he entered into this agreement so that the record label could finance the reproduction and recording of the artist's songs in return to grant him exclusive ownership of the copyright. But the artist only recorded one song and he didn't renew the contract. It was a 1-year contract. He didn't renew the contract. But to his shock, the record label continued using his music and claiming ownership of it on various platforms like YouTube. So he sued the record label, seeking them to be stopped, restrained from continuous distribution of his music, and claimed compensation as well. So judgment was in his favor. But what we learned from this case, especially for the musicians, artists, and various owners of intellectual property, is that before engaging or signing into agreement that touch on your proprietary interest, you should always seek legal advice. You should always have that agreement perused through by a legal practitioner, in particular somebody practicing in field of intellectual property. Let them review the agreement and advise you the effect of particular terms. Then we also see that registering for copyright is very important. Because if you had registered for copyright in your album for the various songs that you have, it's easier claiming that you are the owner. It's easier because you just show certificate of registration and all the various platforms will be able to give you audience. Yes.
Okay. So on the lessons that we draw from that, how about when it comes to the question of moral and economic rights? We've heard that being said in many settings, but what really is the difference?
So the difference between the moral and economic rights is that the moral rights are that we acknowledge that it is you who sang the song. We acknowledge that this is your work, but you are unable to derive economic sense out of it. Whereas the economic rights are that I'm able to license, I'm able to redistribute, I'm able to sell the intellectual property, I'm able to sell your product. Yes. That is basically the difference.
Okay, great. And penultimately, as we reflect on this year's theme, De Klerk, in your opinion, what legal and policy reforms would you propose to ensure that innovation and creativity are better nurtured and safeguarded in Uganda's rapidly evolving economy?
First, when we look at our copyright and neighboring laws, that's a particular act that was enacted in 2006.
Wow!
When you look at the advancement in technology and the advancement in music from 2006 to 2025, there's a big gap. There's a very huge gap. So the act does not accommodate the recent realities of artificial intelligence and the recent realities in the advancement in the digital age. We are looking at the time by 2006, most of these platforms were not functional. And if they were functional, they had not gone through the recent advancement that they have. So when you look at those two realities, you really see that the law that we're using needs some reforms. So if they could give room to accommodate the recent realities in artificial intelligence and the digital age we are in, that would be good. Because right now, the law does not address work that is, for example, it doesn't address work that is generated by assistance from AI. Rather, for it focuses on work that is by the original author. So how do I own work that I got assistance from artificial intelligence? So those are some of the realities we have to put into account. And the Act looks at affixing work to be on a material. And the material here that they were looking at, a cassette tape, a CD, but I could insert my work on my channel. And we are in an age where nobody buys CDs.
Right. I was about to say that.
Nobody buys CDs. We subscribe to these various media and digital platforms like Spotify. People are able to pay a monthly fee to be able to access all music. And we are looking at also in the telecom world where people use various caller tunes which have musicians' songs.
Yeah.
And the mode of computing, how they should be paid, or the mode of computing on how incomes.
Yeah.
Like the musician is unable to know how many people have been able to have my song as their caller tunes.
Yeah.
So some of these are some of the challenges that they are facing.
Yeah.
Yes.
Okay. Speaking of that, De Klerk, do you think that we've done enough awareness creation, especially among the creatives, for them to understand the legal aspects, but also some of the safety valves that these laws, for example, the Copyright and Neighboring Rights Act, some of the safety valves that are in these laws, and if not, what more do you think can be done to create more awareness on the question of intellectual property?
For starters, in regards to intellectual property, I wouldn't think we've done enough awareness. The awareness that is done is more of, it is less. It's unable to reach all the people. And when you look at most of the people that are in the industry of creatives, these are the young people, the youth. You see, some of them are just right out of school and we're unable to reach their circles for awareness. So I believe just as how human rights are taught way back from school, a student leaves school knowing that there are human rights and he has a right to ABCD. So I believe education and sensitization way back from school, it would enable the message reach a wider area and a wider number of people. Yes.
Okay. But what more do you think can be done at a national level for us to protect the intellectual property rights of our creative industry? What more do you think can be done over and above what is being done now?
So far, I think I will have to credit the Directorate of Intellectual Property. They have been doing awareness on the various handles of URSP. So people are able to know what's going on in that stream, and people are asking questions, which is a good thing. Whenever questions are asked, it shows you that people are following. So I believe even as the practitioners, we should keep pushing the message. We should keep publishing. We should keep sensitizing the various individuals who are in the field of creatives about the various intellectual property rights that accrue from their works. Yes.
Okay. So still at the national level, De Klerk, are there any organizations or some sort of structures that we have as of now that sort of serve as umbrella bodies for for the creatives? What are some of those structures that we have at present?
At present, we have the collective management organizations, but with how they've been doing their work, I think they're not really empowering the various people in the creatives, and they're not really advertising or sensitizing why the different individuals need to register with them. Now, for example, we have the Uganda performers' rights. Basically, they're not giving the various musicians or the various artists reason why they should belong to that collective management organization. Because ideally, the work of the collective management organization, it ought to be pushing for enforcement of the intellectual property rights in case of infringement. It should be pushing for payment of the different royalties that accrue from the use of these artists' works. Yes. So the whole thing would be empowering the collective management organizations to show presence and to fund them to be able to reach a wider market, a wider range, or a wider number of people. Yes.
Okay. So how do we get to do that, De Klerk? Because if I understand your opinion in that regard correctly, it's like these umbrella bodies have not given any incentive per se to the creatives for them to actually join them, and so you find that they often do not see any reason to join them. So how do we actually empower these bodies to have incentive for membership, especially because we know that if the creatives are brought together, then they're able to advance their rights, to advocate better for the protection of their intellectual property rights, but also to sort of access remedies. It's much easier for them to access remedies in case of infringement when they have some sort of umbrella body that they belong to. So,
with the collective management organizations, typically we are looking at. You see, it's harder for a particular artist to move to each media house in claim of his royalties. But however, it's cheaper if the collective management organization is able to collect all this and remit to the client. But you see, the challenge is that in order for the collective management organizations to help the artists, to help the creative industry grow, they have to encourage these particular individuals to register for their works. Because once your work is not registered, you are unable to benefit from the benefits that accrue from registration. Yes. So maybe I think last year there was a training at URSP where they invited various players in the industry, encouraging them how it's easier or why it's necessary for collective management organizations to be in place. Because as a block, there's a huge bargaining power. As a block, there's strength. As opposed to having different individuals set up different clusters or different groups to be able to claim. You see, as a block, you are even able to have government have a conversation with you in regards to what the realities of the field or an industry are. Yes.
Okay, interesting. As we start to get to the conclusion of our discussion, I just want you to talk about some of the services that we can offer in that regard here at Kalikum Timan Company when it comes to the protection of intellectual property rights.
Here at Kalikum Timan Company Advocates, we have a whole fully fledged department for intellectual property. We handle registration for the various intellectual properties that one claims. We handle document review and advisory. That is for those that tend to have engaged into agreements to license, to redistribute, and to become brand ambassadors to these various entities. And we also offer the service of following up, monitor. We have a a system that we are able to follow up and monitor the various intellectual properties assets for our clients, and trying to monitor their usage on the various platforms. Yes.
Okay. Speaking of infringement, I probably should have asked this question much earlier, but what form does it usually take when it comes to infringement?
Infringement occurs if there's unauthorized use of your work, unauthorized distribution. As long as you don't, you've not consented to your work being used anywhere.
Yeah.
You've not consented to your work to be distributed anywhere. That is an infringement. An infringement would also occur if your work is wrongly misused. Because as we speak, your work is your asset. So if you are not happy with how that work is being used, you can always terminate that. You can always terminate that association. Yes.
Okay. So, what advice do you give to those that are listening to this discussion today when it comes to the protection of intellectual property rights? What advice do you give them?
The advice I would give for those that are listening in, intellectual property is a very valuable intangible asset. It's a brand. It's what identifies you. It's what the whole world is able to see in you. So I would advise for those listening in, especially the people in the creative works and also the business community, that having ownership of your work is a very good thing. And in the world where we're moving in, and intellectual property, it can be valued. So we are moving into a world where what would aid you get money is just your certificate of registration, because they are able to see what it's worth. Yes.
So there could be someone listening in, and already they are in a situation where, quote in quote, their idea was stolen. But as you know, an idea cannot be stolen per se when it comes to intellectual property law.
Yes.
What solution might they have then, given the circumstances?
Basically, an idea cannot be stolen. If that individual is able to put it in material form, then an idea is never stolen. It can be actualized into reality. Yes.
Amazing. Thank you, De Klerk. That brings us to the end. I just want you to share some parting shots to our audience in light of the discussion that we have had. Just do share any general parting shots.
As we close off,
Yeah.
we are in a world where intellectual property is where intellectual property is could be the difference between passion and a job. That to get economic sense from the creative works, you should do you should go an extra mile to see that your works are protected. And your works could only be protected through registration. Yes.
Okay. Thank you so much, De Klerk, for sharing your thoughts. And to our listeners, that has been our discussion today on World Intellectual Property Day 2025. And we just want to encourage you. You could be a creative, or you're in the music industry, or whatever you're doing that can really be considered intellectual property. We just want to encourage you to seek legal guidance. And of course, we remain readily available to help you in that regard when it comes to the formalization and recognition of your rights, but also to ensure that they're actually protected, because as you've had through the discussion, we are in the digital age.
In the digital age.
Yes, and so you find that while you're still thinking about registering your interests,
somebody else could be doing the same.
Yeah, someone else could, be thinking of doing exactly that, and they can go before you. And I know Ugandans like doing that. Where you can be part of the discussion, and then you think of registering.
Somebody has already done that.
Someone has already done it, and they don't even. They're not even going to use it. They don't have a vision for it, but they just go ahead and register it in their name, and then they'll keep quiet. So by the time you make your mind up on registration, then you have to look for them.
So we encourage all the listeners that they should make sure you always seek legal advice for any of the proprietary rights or interests that you claim could be yours. And we are also ready to serve you to actualize your ideas into reality. Thank you.
Yeah, great. And of course, many a time is of the essence, because as you take your own time, there's someone else, as I was saying in the beginning, who might go before you, and then you find yourself in a very difficult place where now you have to reach out to them, then negotiate with them. And of course, at that time, you're negotiating, on their terms.
Yes.
Right. And so you find that then you probably have to pay them off. Moreover, for your own idea and your own name, you have to pay them off so you can actually get to use the name, or to actually get to own the idea that was in the first place yours. So we want to encourage you to move fast. Because sometimes you want to take your time, but when it comes to intellectual property, time is of the essence. Yes, because if your idea is stolen, quote unquote, then it's how do you convince the registrar that was your idea?
That was my idea.
Yes, and someone else.
It's really a long shot.
It's a long shot.
To convince the registrar.
Yes, it's a long shot. So you'd rather on the side of caution. And of course, as the clerk has mentioned, and the clerk is our team lead intellectual property here, we remain readily available to help you to walk this journey with you, and every step of the way. Yes, so we've helped a number of our clients when it comes to copyright, when it comes to, by the way, the clerk, what are those forms? I know there's copyright, the trademarks. There's copyright, trademarks, industrial design, yes, patents. Yes. Wow. So it's quite a wide. It's array. Quite a wide. And of course we have expertise in that regard to support you and to meet all your needs as far as intellectual property is concerned. Okay, great. Thank you so much, the clerk, for sharing your thoughts. And to our listeners, we are still really in the mood of celebrating World Intellectual Property Day, and we want to thank you for joining in the discussion today. Please do continue the discussion on our socials, but also if you have any question, please do pose that question in the timeline, then we'll be able to respond, and if it needs to be escalated to have a deeper engagement on the question you might have, will also be available to help you in that regard. Thank you so much. Until next time, I remain Howard Mwesigwa.
Karikumtima and Company Advocates, translating visions into reality. For more information, visit our website www.karikumtima.com.